floor, Mr. President, I'd like to speak briefly to the Second Amendment I have filed, and which I also seek a vote since the Udall Amendment has failed. That is Amendment number 1126, which would prohibit United States citizens from being held in indefinite detention without trial or charge. As members know, Section 1031 of the underlying bill updates and restates the authorization for the use of military force that was passed on September 18, 2001, 10 years ago, 1 week after the attacks of 9/11. The provision updates the authority to detain terrorists who seek to harm the United States, an authority that I believe is consistent with the laws of armed conflict. However, I strongly believe that the United States government should not have the ability to lock away its citizens for years and perhaps decades without charging them and providing a heightened level of due process. We don't pick up citizens, we don't incarcerate them for 10 or 15 or 20 years or until hostilities end, and no one knows when they will end, without giving them due process of law. So my amendment simply adds the following language to Section 1031 of the underlying bill. We would add this language: the authority described in this section for the armed forces of the United States to detain a person does not include the authority to detain a citizen of the United States without trial until the end of hostilities. It's hard for me to understand any member of this body that knows and respects the Constitution wouldn't vote for this. Because without this amendment, Congress is essentially authorizing the indefinite imprisonment of American citizens without charge or trial. As I said on the floor earlier, 40 years ago, Congress passed the Non-Detention Act of 1971 that expressed the will of Congress and the President of America that America would never repeat the Japanese-American internment experience, something that I witnessed as a child, close up and personal, and would never subject any other American to indefinite detention without charge or trial. In the 40 years since President Richard Nixon signed the Non-Detention Act into law, Congress has never made an exception to it. Now, the issue here in this bill is the Congress making an exception that has never been made before by the Congress. And what we are saying is it is okay to detain an American citizen without trial ad infinitum. I don't think it is. I don't think that's what our Constitution is all about. The provision in this bill threatens to do just that. And so I ask unanimous consent to enter into the record a column published yesterday in the San Jose Mercury News of California from Floyd Morey. Matter of fact, I know Mr. Morey well. He is the National Executive Director of the Japanese American Citizens League, which is the oldest and largest Asian American civil rights organization in the United States. The Japanese American Citizens League, or JACL as we would say, has been an active voice on the wrongful internment of Japanese Americans during World War II. And I believe it's worth listening to what they have observed from that painful history. The administration has threatened to veto this bill and said the following in its official statement of policy, and I quote, "After a decade of settled jurisprudence on detention authority, Congress must be careful not to open a whole series of legal questions that will distract from our efforts to protect this country," end quote. Yet, by allowing the military to detain United States citizens indefinitely, Congress would be opening a great number of serious legal questions, in my judgment. This amendment would restore the language that was in an earlier version of this bill that would have established a similar ban on the indefinite detention of U.S. citizens. It is also consistent with the way we've conducted the war on terror in the past 10 years. In cases where the United States has detained American citizens, including John Walker Lynn and Jose Padilla, they have eventually been transitioned from indefinite detention to the criminal justice system, and both have been convicted and are serving long prison sentences. John Walker Lynn pled guilty to terrorism charges and was given a 20-year sentence. And Jose Padilla was convicted of terrorism conspiracy and sentenced to a 17-year prison sentence. So I believe this amendment is consistent with past practice and with traditional United States values of due process. We are not a nation that locks up its citizens without charge, prosecution, and conviction. My amendment reflects that view. I believe in that view, and I hope this body does as well. So I urge its adoption. Mr. President, in conclusion, I ask my colleagues' support on these amendments because I believe they will improve the legislation. I yield the floor. I note the absence of a quorum.
The Secretary will call the roll.